Good afternoon, everyone. My name is Liam Gallagher. I am on the executive board for the Maine Labor and Employment Relations Association. I just have a few quick announcements before I turn it over to our speakers this afternoon. The first one is our next regularly scheduled program will be May 12th. The subject is to be determined, but we should get some information out before the end of the month on that program. Secondly, just a matter of housekeeping, if you are an attorney looking for CLE credit for today's presentation, you can please raise your hand virtually so that Annalee will take stock of who's in attendance who would like that credit. And from here, I'm going to turn it over to Christine, who's going to introduce our panelists and our segment today. Thank you.
Thank you, Liam. I want to thank everybody for joining this LERA-Maine webinar. This is on technology and AI, the impact on dispute resolution in the workplace. I want to thank Liam. Thank you for doing the opening and hosting today, as well as my colleague Paul Gaspar for coordinating a lot of the Zoom, and of course Annalee Rosenplatt, who takes care of us very well, and for her work on the CLE. It takes a village to get it all done, and I want to say thank you to my colleagues. My name is Christine Newhall. I'm a senior vice president at the American Arbitration Association, and over the last 2 years, maybe it's 3, Bryan will correct me, I have watched and experienced great innovation as it relates to the use of technology and specifically the use of AI. Today, you will hear from my colleague, Bryan Corbett. He's going to share his experiences with the use of AI. He is the Director of Innovation at the AAA and has a wealth of information and experience to share with you today. And watch the chat because I think he's going to provide you some very interesting information for you to look at after this webinar, but not during the webinar, unless he tells you to do so. Also with us today is arbitrator and mediator that serves on the AAA panel, as well as for the FMCS and the National Mediation Board, as well as service on many private, public, and federal sector permanent labor panels. Thank you, Keith Greenberg, for joining us today and sharing your perspective on technology and how AI is impacting dispute resolution. We will today welcome your questions, and please feel free to put your questions in the chat. We have also reserved time during the latter part of the presentation to have direct questions to the panelists. We hope you will provide your questions today and share with all that are joining. So let's start this exciting journey on how AI and technology are impacting the workplace and the dispute resolution process. I want to share with you that my colleague Bryan took my agenda. It was very rough draft. And you know what? He used ChatGPT Enterprise to make my agenda better. And it is much better. Maybe not in all the same language that I would have used, but it definitely helped us get to the event today. So I want to thank Bryan and Keith for working with me on this webinar and for sharing with us their expertise and also their perspectives. So let's start with Bryan on AI and dispute resolution, your insights and experiences. Bryan?
Sure. Thank you, Christine. And it was November 2022 when ChatGPT first became available. And so it's been a little over 2 years. So I thought I'd start by talking briefly about the AAA's AI journey, which we really approached in phases, the first being very exploratory. In November of 2022, we put together several pilot groups consisting both of internal case administration staff as well as some of our panelists to explore various Gen AI platforms and identify potential use cases. we were excited about AI. We are AI optimists, but we needed to figure out the best way to use it, which I know is something a lot of people have spent the past couple years trying to figure out. So, for example, one of our panelist groups used ChatGPT, Claude, and CoCounsel, excuse me, which is a legal tool, AI-powered legal tool. And they used these tools in their ADR practices and compared the output, excuse me, and compared the output from the different tools. They wrote an article on their findings that was published in the November 2023 Dispute Resolution Journal. That article is posted at the Triple AI Lab. The Triple AI Lab is a fantastic hub of various resources related to AI, trainings, different educational webinars, articles, and I'm going to post the link. That's the first link I will post today. I will post that link in the chat so you can check it out later. And that's where you'll be able to find that dispute resolution article about the findings of those arbitrators, which this article is from November 2023, but opinions haven't changed much. Most ADR professionals and most legal professionals are using AI tools to augment their skill set and their knowledge, and understand that it's a tool that is meant to do just that, be a tool and not replace humans. And we'll talk, I'm sure, plenty about that as this session goes on. But once we moved from our exploratory phase at the AAA, we moved into integrating AI into different workflows and services we offered. So I'll quickly tell you about a couple of those. We started by updating our clause builder tool, which is a free tool that's been available for years in its traditional form online, that helps users draft ADR clauses for contracts. Now Clause Builder is known as Clause Builder AI. We incorporated Gen AI into the tool to enhance the user experience. We've also released new arbitrator search tools, both internal and external. So the internal tool is used by case administration staff to help them draft a list of potential arbitrators to provide to parties for selection. And the external tool is for parties that have filed a case with the AAA to assist them in selecting an arbitrator for their dispute. So these tools are interesting because they use semantic search. Semantic search is a technology that uses natural language processing. That's a traditional form of AI, different from generative AI. And it understands user intent and it understands context. So it provides more relevant results, which is why it was a great technology to incorporate into the search tools. Beyond that, we've also...
Bryan, can I ask a quick question on to share with the audience some feedback from the parties that are utilizing the arbitrator search tool? I have heard that there is positive responses to it.
Yes, absolutely. It's been, it really is one of those tools, one of those processes that just seems made for an AI enhancement, and it's worked out very, very well.
Okay, thank you.
Yes, absolutely. So beyond that, we've also enhanced some of the options available to parties in our online case management platforms, web file for the parties, the e-center for our panelists. These enhancements include document summarization. One of the best things AI can do for you is summarize documents, and also document Q&A, where the user can select a document and ask questions of it and get AI generated responses. So that's been one of our more recent enhancements we've made. Finally, and more recently, we partnered with ClearBrief. You may or may not have heard of ClearBrief. and we partnered with them in order to offer their platform to our panelists. ClearBrief is basically a Microsoft Word add-in. It provides document analysis, hyperlinked sources in briefs, and the user can generate timelines and table of authorities, things like that. So that is sort of a snapshot, and we have a lot more coming. We have several internal teams that focus just on AI. So we're excited about what the future holds. Again, we are definitely AI enthusiasts and optimists, of course, while also recognizing some of the challenges and risks that come along with that. And then outside of the AAA, I could just touch on some of the use cases in organizations and in certain workplaces. Many organizations have introduced AI chatbots. We actually launched one today, Christine. I'm not sure if it's been formally announced yet, but we put a chatbot on our website that external users can query to ask case filing questions. But many workplaces have released AI chatbots internally that help address employee questions, complaints, and conflicts. So this goes through the HR department. They're basically virtual HR assistants that can provide policy information and guide employees even through dispute resolution steps. And I know that AI is beginning to assist mediators and conflict coaches in workplaces. Fully autonomous AI mediation is still relatively rare in workplaces, but AI tools are certainly beginning to aid human mediators. There are systems that can analyze input from both sides and suggest possible solutions or even ask questions to help the parties reach a settlement. So there's a lot going on, but there's also a lot of questions around it. So we're definitely living in interesting times. The best thing to do is to try to stay on top of it and not ignore it, because as we'll talk more about, it's definitely here to stay.
Thank you, Bryan. And glad you went from AI optimist to AI enthusiast.
Yeah, I always switch between those two terms.
Well, thank you very much. And I know you will be sharing with us some of the challenges later on in this program, but thank you very much, Bryan. Keith, can I turn it over to you for your perspectives?
Of course. Thanks, Christine, and thanks, Bryan, and thank you all for having me here today. So I want to give you a little bit more by way of background about me, because what I do and what my practice is like informs my perspective, and my view isn't the only view. So I'm a member of the National Academy of Arbitrators, and my practice is a mix of labor management grievance arbitrations and interest arbitrations, employment arbitrations, MEPA and pension arbitrations, and mediations, and really all of those areas too. And that's part of what informs my perspective. The other is that I really enjoy using technology appropriately in my practice. And I've had the pleasure of serving along with Christine on an AI study group that the National Academy of Arbitrators has stood up over the past year or so, and that has started to look at the use of AI, particularly in labor arbitration, but in dispute resolution a little more generally too. We have some study results to share with you from a survey of National Academy members, and we'll get there in just a moment. But I wanted to frame for the group the areas where, at least from my seat in the process, I see AI coming into dispute resolution, particularly in arbitrations. Sometimes AI is really the source of the dispute in the first place. So, for example, folks whose jobs are being replaced in whole or in part by generative AI technology. That I'm sure my colleagues are seeing in grievances, and I'm sure it's an issue we're going to confront more often in the future. And that actually doesn't strike me as all that different from a lot of the other types of technological change that we've seen in the workplace for as long as there's been a workplace. Things that used to happen on with pen and paper happen on a computer, maybe take less time. Things that would take days to work through by hand, a computer can do in a few seconds. I'm not sure that this is that different. It may be more complex. It may be more of a challenge to parse through and figure out exactly what's happening, but conceptually, technological change is nothing new in the workplace. Another area where this comes up less in labor management arbitration, more in employment cases, is potentially, for example, the use of AI in hiring and in making, in assisting with screening and those sorts of things, certainly at the front end of the employment relationship and potentially in other parts too. And that's a little more complex because we're talking about, even if it's at a low level, some decision making and an understanding of, well, how is the generative AI separating, for example, applicants into a pile to say thanks but no thanks to right off the bat, another pile maybe to bring in for an interview with a recruiter, or maybe a selection of highly ranked applicants that should get a little more attention even than that. But in that sense, we're talking about where AI is really part of the issue. I also see AI where it's an issue at hearing, where AI has been used maybe to create evidence. For example, taking an audio recording and turning it into a transcript, or where it's used for analysis for the benefit of the arbitrator or the arbitration panel. Here's a summary of what all these documents say. Or in an interest arbitration where you're looking at complex financial information and budget information potentially. And so, you could see it that way at a hearing too. Next is where you see the advocates use it in their presentation of the case. And the one that I know I've heard about a lot in the news the last couple of years is where an advocate uses AI to help write the brief. And the AI I'd say gets a little creative, but it's more serious than that, right? The AI hallucinates some citations that the court site checks, even if the attorneys didn't, and the court has some things to say about that, and I imagine an arbitrator would too. And lastly, how arbitrators use AI, if at all, in their practices. And I think especially in those last three categories where it's used in presentation at the hearing, where it's used in presentation of arguments, and when arbitrators might think about using it, the key word, and it's another way of putting what Bryan put out there, is personal responsibility. And the other way to say it is augmentation, right? That this is a tool, and that ultimately there is a person who is using that tool who's responsible for how it's used. And that's going to mean different things in those different contexts, and there are different considerations that come into play. But ultimately, this is a person at the end of it who's making these decisions and who's exercising some judgment about how and when and under what circumstances those tools get used. So turning to the survey, in late 2024, the National Academy of Arbitrators, with support from the Academy's Research and Education Foundation, and in collaboration with Cornell University's School of Industrial and Labor Relations, surveyed members of the Academy and on their use of AI. And this is a fast-moving field, and so one thing to think about is these results are the better part of 6 months old, maybe even 9 months old as we sit here. And so the state of the profession may have changed some. I don't know that it's changed a ton yet, but we are looking at relatively old data if you think about it, given the nature of this topic. And so let me give you some of the key findings and takeaways out of the group. And you should also remember the Academy is a group of experienced arbitrators of labor management disputes. The group skews older, at least compared to me. We're talking about folks who've been doing this for a long time, as have I, but usually often after a second career, or others for many decades. But it's a group that skews into their, I'd say into their 60s for the most part, and there's a different level of comfort with technology too. And it's something that I had the pleasure of helping with during the pandemic when we got labor arbitration moving on to Zoom. It takes some work to have arbitrators get that comfort level with the technology and that comfort using it, or figuring out not to use it, as the case may be, and we'll talk about that more. But so of the respondents to the survey, only 13% reported using generative AI tools in their professional neutral work. So that leaves 87% who said we haven't used it at all, at least in connection with our neutral work. And most of those who had used it for arbitration tasks as opposed to mediation tasks. And we can talk about that more a bit later, where that's really how the use cases might differ and how the considerations might differ there. One of the biggest barriers to adoption that respondents told us was that were ethical considerations, specifically with respect to confidentiality, bias, and accountability. More than half of the respondents identified the ethical concerns as one of those barriers. A significant number indicated a lack of awareness or knowledge about these tools. There were privacy concerns and skepticism about the benefits of AI, and those privacy concerns loop back into those confidentiality concerns that were drawn out too. There were a fair number of folks who said, I'm not going to be doing this that much longer. This is not high on my list to learn before I start to wind down my practice or given the caseload that I keep up. That's a fair perspective too. I will share with you a few of the quotes because we have sort of quantitative responses and some qualitative ones, and a few stood out. We had some respondents say, I don't think it's right to use it for the work an arbitrator does. Another perspective was, it's for lazy people. Another said, I don't wish to use it. It's not what the parties bargained for. Another said, AI doesn't seem like a reliable tool. Another said, I'm not sure it's ethical. And to balance that, others said, if I could depend on it not to hallucinate, that might be helpful with research and doing some prep work. Or it could be useful for condensing and understanding large volumes of data or information. But those were some of the qualitative responses, and plenty said, I'm just not familiar enough with it to have a real opinion about it, know whether this is something that's going to be useful for me. So let me turn a little bit to the uses that respondents indicated they're making of AI when they're using it. So one of the major areas, and when I say major, this is still out of a relatively small number who are actually using it in the first place, but respondents indicated they use generative AI for document searches, for summarizing briefs or case law, for researching prior awards or decisions. A small number indicated they were using generative AI for drafting standard parts of their decisions or for editing. But very, very few indicated that they were using AI for any kind of what we call critical tasks like drafting actual decisions or reviewing cited cases. So there is interest, as we learned from the survey, in training. And so the respondents, a majority of them said, we'd like some training on how we could use this, even if we're not sure we want to be yet. At least from the arbitrator's perspective, it was interesting to find that a very small number of neutrals, it was identified at about 4%, reported knowingly encountering advocates who are using generative AI in their work. So they're not seeing it yet, at least in their hearings, in their cases that they know of. And I think that summarizes much of sort of what the reaction was. We're not sure if it's ethical. We're not sure how to use it. Some of us really aren't interested, but for those who are, we need to know more about how we should use it, how we can use it, and what those appropriate uses are. And what we hear the respondents asking for is that training, demonstrations of how AI can be used, especially for tasks other than actually coming to the decision, and clear ethical guidelines to address concerns about confidentiality, bias, and accountability. And I can pause there for a moment and Bryan, see if you've got anything to add there, or Christine, anything you wanted to follow up on before we move away from the study.
Yeah, regarding the ethical challenge, the concern there. The question becomes if a biased AI recommendation leads to an unfair decision or output, who is accountable for that? Is it the human? Is it the software? Is it the company of either? And I think we're going to be asking that question for a few years to come, but I wanted to highlight that this is why transparency is so important when it comes to the use of AI. You know, transparency that the arbitrator's using it, transparency that the parties are using it. You know, we of course want the arbitrators to disclose the use of any AI that's supporting them in any decision making, if they're using it as a tool to support their decision making. But we also encourage parties to disclose how they're using AI. Many arbitrators will ask at the beginning of a case, once they're appointed, they will ask the parties if they intend to use any AI throughout the course of the proceedings. So I think transparency is really, really important. At the end of the day, arbitrators, they have to exercise independent judgment, and the decision-making really, it remains the sole responsibility of the arbitrator. But going back to that question of who's accountable, this is a reason why I think that parties, they should have the opportunity to know and to challenge the use of AI in any ADR setting, which is why I think transparency and just knowledge of that is so important.
And I hope that, go ahead.
Oh, go ahead.
No, go ahead, Keith. I'll go after you.
So I think, Bryan, you got it exactly right when you talked about the use of AI for decision making, because the parties bargain for their arbitrator, right? The parties are making that choice, and the parties are expecting the independent judgment of the person they select. And I think that's the reason, and appropriately so, that there's, that based on the survey results, based on what I see in my own practice, based on what I see in the profession, there's hesitancy about by arbitrators about using these tools and figuring out what the right use is, because ultimately, unless the parties have agreed to something else, the buck stops with us. The buck stops with the arbitrator, and we are, meticulous about our work, about reviewing the record, about reviewing the contentions, about the basis and the analysis and the rationale for our opinions and awards, because the beauty of arbitration, certainly in labor management cases, and frankly in employment, in pension, in any of these areas, is that we provide a final and binding resolution to the dispute. In most cases, in most situations, unless the parties have bargained for something else or the law requires something else, there's nowhere to go after us most of the time. We're not courts that are subject to appeal. There's no place to fix a mistake that an arbitrator makes because they've relied too heavily on AI. And there's no, I don't think the parties get any comfort from hearing from an arbitrator, oops, the AI did it, if they were ever to get that in the first place. And so I think from the arbitrator's seat, slow and cautious and steady about the use of AI is probably the right approach. And especially we have to be on guard about how the use of AI potentially substitutes for our judgment in any aspect of crafting the opinion or award. And so from my seat in the process, augmentation, AI as a tool is really the right notion, but in a limited way. And it's different, I think, for folks in the other seats in the room. It's different for the parties. It's different for the advocates, because the job is to present the case in the most effective way for the advocates in particular, right, subject to their ethical obligations. And so it's important to get it right. But like I said, the buck stops with us. And so, there is, and we can talk more about the right tools for that. And I think, the generally available AI tools are probably not right for a lot of what we do as arbitrators. Some of the tools that I know that, Bryan, you mentioned have the potential to be really helpful in that sort of augmentation context, and we can talk about that more too. Christine?
Yes, I just wanted to highlight the training area. We are hearing from many panelists that we want more, we want to know more. And maybe, Brian, you can highlight how Clearbrief has in their relationship with the American Arbitration Association that they will be available on a one-to-one to even assist with the use of that tool in terms of documentation, how to use it. You probably have better information, but it's interesting that a company that we are partnering with is very intent on how can we be your education partner. Brian, do you have anything to add to that?
Right. Well, yeah, and I'll just reiterate that training and education is so important for any user of AI. You have to understand not only what the tool can do, but what its limitations are. So we all know the story of the attorney that cited fake cases in a brief, and that was early on when ChatGPT first came out. But admittedly, that attorney he didn't know that AI could hallucinate, that ChatGPT could hallucinate. And really the value you're going to get out of an AI tool is in direct relation to your understanding of it. So education, I think is paramount, training. And Clearbrief, yes. The Clearbrief understands that. And we have arbitrators that are excited to see how this tool can benefit their ADR practice, but they're willing to admit, I really don't understand how it works. But Clearbrief is, they will conduct webinars, they will, schedule just one-on-ones with arbitrators to walk them through the steps, do the demos, make sure they're comfortable with the tool before actually putting it in practice. And if, I did post a link to the Triple AI lab, but AAA published principles on the use of generative AI in dispute resolution. And one of those principles is competency. It's just of the utmost importance to understand how the tool is working and what it can and cannot do.
Thank you, Brian. I'll turn it back to you, Keith.
Sure. So, I see we've got a question in the chat about mediation, and I think there's an interesting contrast between how and where the concerns and optimism are for AI use in arbitration versus mediation, because the roles are really different, right? In arbitration, the arbitrator or the panel has decision-making authority, and in mediation, unless you're talking about a meet-arb or an arb-meet or some kind of related process, the mediator doesn't. And some of the concerns are still there, right? We're talking about confidentiality, privacy, all of that. And when you're looking at using an AI tool, those are sort of paramount concerns before you put other people's business out where it shouldn't be. But one of the things AI brings is, I don't know if creativity is the right word, but it's a good enough word. And so I could imagine a situation where a mediator is working with parties and mediator is just out of ideas, right? And maybe there's some value in bouncing off ideas uh, against generative AI to say, well, can you think of anything else? What other strategies might work? I'm out, but doesn't mean there aren't other ways to do this. Or I'm hearing this from that party and that from that party. What, am I missing something? And to be able to do that and kind of pull in that second brain a little bit and make some use of it on the fly. Again, if you've got appropriate confidentiality and privacy protections built in, because ultimately in mediation, anything that ethically gets the parties to a resolution, it gets the job done. The goal is get the resolution that the parties have asked you to get and to help them get. And if you do that by, bringing in candy or donuts to make them less hangry at the end of the day, or you do that by putting out a suggestion that an AI gave you that they buy into, I mean, in a situation where the parties retain agency, they retain decision-making power in mediation. That's what they do. They keep control. Whatever you can put into the mix that helps that and helps the parties get where they're trying to go, I think is probably all right as long as it's within the mediator's ethics and not breaching confidentiality through the use of the tool. So I think there's some potential there. Bryan, what do you think? I know you've seen
Yeah,
a couple of examples.
yeah, I agree. I think that mediators can use AI tools to make some suggestions. Of course, you want to be very careful. No one should be putting confidential information in publicly available AI tools like ChatGPT. There are versions of ChatGPT that offer enterprise level security safeguards and other ways that users can protect data, but that doesn't mean you can't use it. You can redact, you can anonymize data so you're not including personal names when you're using a publicly available tool. So there's ways to go about it that would put you in a better place as far as the potential to leak any confidential or proprietary information. And I'll share a quick story I read recently about a mediator who used ChatGPT to suggest a settlement amount. And the mediation had resulted in an impasse, but he did use ChatGPT to get the settlement amount. He went back to the parties and he said, look, I used ChatGPT. I have your settlement amount. You either go with this or, we're going to you either go back to negotiations and we'll continue this session, or we're going to go with the settlement amount provided by ChatGPT. And the parties were immediately, oh, no way, we don't want ChatGPT to decide what our settlement is. So that put them back into negotiations. They ended up settling, and I think the amount was around $150,000 was the settlement amount, but the mediator then let the parties know that it was only $5,000 off from what ChatGPT had suggested. So what's interesting about that story is that the mediator used it, he leveraged AI in a very unique, unconventional way to get the parties back to talking to each other and coming to a settlement. And also the parties that gave them some faith in the AI tools. They were impressed with what the tools output was.
And I know one of the things in preparing for today, one of the things we talked about was concerns about bias, where that can come up and what's built into some of the tools. And each of us comes to life with some bias, right? Based on our experience, based on education, based on any number of things. And that happens with AI too, right? Because those we're talking about a human created tool, and so we bake in some of our own views of the world when we do that. There are sometimes, I think, and this is, I guess, part of being an educated consumer and an educated user of these tools, some may have more blatant biases than others. And I'm thinking of what I've read in the news recently about a product called DeepSeek R1. Bryan, I'm guessing you've come across this one that was editing isn't the right word, but taking particular perspectives on particular issues. For example, if you asked it about the Tiananmen Square massacre from the late 80s, because the product came out of a Chinese company, and that was not something it was willing to deal with in the same way that another product might. I think Grok, which was Elon Musk's product, had particular things to say or not say if you asked it about him. And those are just examples that have been in the news relatively recently. And so I think that training that you've heard emphasized, the familiarity with the tools and what they do, and whether you're using the right tool for the right task are really important so that you know what you're using. And I can imagine, even if someone is developing, say, a tool that has been trained on arbitration awards in a particular industry and can be helpful in that sort of scenario, might not translate well to a different industry with different norms and different considerations and different customs. And so the right tool for the right task, I think, is really key there. But Bryan, let me kick things back to you if there are other areas you wanted to focus on bias and where it's maybe more of a concern or maybe less so.
Yeah, well, the most important thing is to recognize that bias does exist. AI does not create bias in and of itself. Rather it mirrors human bias, because bias does exist in those data sets. And early on, OpenAI was very open about not even knowing everything that was in some of their original data sets, because there was so much information. And so, of course, there's going to be bias in those data sets that these large language models are learning from. But bias in AI it's easier to stop something that can be seen and measured. So AI bias can be quantified or systematized, if you will, in a way that makes it more transparent, which is a good thing. So that is my glass half full response to the bias concern, because we can actually look for it and remove it. And, moving forward, we can create data sets with, removing the bias as they're created and make sure that it doesn't exist, which is already happening. Some of the companies that are developing these data sets and these new models, they are making sure to remove bias from them. And that's also, it falls onto the responsibility of the user. You may have heard of the concept of human in the loop, and that is just a human providing oversight to any AI tool that they're using and the output of the tool. And that means reviewing it and being able to identify potential bias and making sure that that's not used in whatever your final product may be.
So Bryan, you have seen bias comes up so frequently as a challenge, right, in this area of AI. From 2022 to 2025, you've seen improvement based on the human loop.
Absolutely, because the models, even just focusing on the models that OpenAI has released, they continue to get better and better. OpenAI is learning from past mistakes. When you talk about bias in these AI data sets, it goes all the way back to the development of that data set and bigger issues about certain regulations, and the fact that the companies that create these data sets have a diversity problem. So even those things are starting to become to get addressed due to the use of some of these data sets in these AI tools. But it's certainly improving. It's getting better. It's not that the problem still exists, but it's moving in the right direction.
Thank you, Bryan. Keith, did you want to elaborate on the bias?
No, I mean, I think it depends on the use case too, right? I guess when I think about all of this, right, the good news for me is that as an arbitrator, parties select me for my judgment, and that's not likely to be replaced anytime soon by generative AI. And might be able to give you an example in a couple of moments. The bad news is that there is a limit to, how an AI tool should be used in the course of that decision making and that application of judgment. And so I think and just looking back at the study results and the responses from the arbitrators, at the point where the arbitrators are saying and are concerned about, using AI to make decisions, I think that's the wrong question, because the AI shouldn't be used in that way unless that's what the parties want. Bryan, like you said, it's disclosed to the parties, hey, I'm offloading my decision making to an AI. I can't imagine at this point that that's an arbitrator that gets used very often, because that's not something the parties, I think, are expecting. If they really wanted that, they could flip a coin too to resolve their dispute, and we all are busy and doing good work because that's not what parties want. So that's sort of the wrong question. And I think if someone were to use AI to inform their decision making, that's where those bias issues, I think, are the most troubling, at least on their face. Taking a step back and trying to figure out, well, where could we use this as a tool for summarizing voluminous information, for synthesizing information. I think it's still a concern there to the extent that you have a decision maker relying on it, but it's a step removed from actually making the decision. And if it is a tool that's supplemented by the arbitrator doing what they're supposed to do, reviewing the record, reviewing the briefs, reviewing the cited cases, then maybe that's a little less of a concern there because you have the decision maker that the parties have bargained for doing what they need to do. If you take it a step further back and you're using those summaries as a means of laying out what goes in the award, right? Based, as a way of, say, constructing a timeline that's going to go into the background section of the opinion. That the arbitrator is then checking. Well, that's an additional check on these biases because ultimately, you're getting a skeleton of content that the arbitrator is going to check and flesh out and use, and there's that opportunity there to deal with that too. And so I think it is a concern. I think the concern varies depending on the use and depending on the tool, and the more specialized the tool and the more targeted at the particular kinds of uses we're talking about, like what I've seen in the demos of ClearBrief and Bryan, like what you've described and what other tools like that are doing, the better shape the process is in and the less concern I have about those biases, even though it kind of requires some vigilance throughout. But I've got an example, if it helps, I can toss it on the screen of something I have fun, again, not sure it's the right word, but I keep a local large language model on my computer every once in a while to see what it'll do with these sorts of things. And so it doesn't send any data anywhere else, but it gives me a sense of what some of these models do. And some of the newer ones, they call them reasoning models, kind of show their work before they give you an answer. They actually take a little bit of extra time, a couple of minutes, and in quotes, think about the prompt and think about how they're going to respond and lay out that thinking and then give you a response. And so yesterday I took the study results from the AI study group survey and put it into the model. And then I asked it something mostly unrelated from what the study was addressing. I just asked it, what is the National Academy of Arbitrators? And I know Christine has seen the study, Bryan, you may have, but I will represent to all of you, it says very little about the Academy itself, which is fine. It doesn't need to say much. This is about AI, but let me put something on the screen for you. Because it really, let me make sure this is coming up right. Let's see, can you see that Word document there? And some of us are visual learners, some of us are auditory learners, but let me tell you what it does. I asked it what the Academy is. And so this first part here is the AI thinking, such as it is? And it says, well, I have to figure out what the Academy is based on the information given, which is not much. It says, all right, the National Academy of Arbitrators, that sounds like a professional group for people who work as arbitrators. And for those of you who may not know, this is a group of primarily labor arbitrators, certainly labor and employment. But the AI isn't getting that. And so it thinks a little more and says, well, they asked for a report on AI adoption, so they're interested in technology. They worked with folks at Cornell, and I left Mark go at Penn State. I didn't mean to leave at Penn State in attributing the work that we did here. So it makes some inferences and assumptions based on that. It makes some more assumptions, and it goes on to, as we scroll down, very confidently make some assertions about the National Academy of Arbitrators that it doesn't have any basis to know. And I'll tell you a few things. First, this is sort of a generally available model. It's not specific to dispute resolution or legal issues or anything else. But it just lays out without telling me, I'm making the assumption, or I don't really know, but this is what I think, or this is what I'm guessing. It very confidently lays out what it thinks this academy is without a whole lot of basis for it. And so that's the kind of thing that, you want to be a knowledgeable consumer. You want to understand what's going in and what's coming out. And if what's coming out matches the sort of thing that's going in. And it's just, it was a bit of an object lesson in know what you're working with and understand the limitations of the tool and the uses for the tool. And I will tell you that when I ran through the report and said, give me a summary of what's there, did a much better job, right? Because it had the data and it had the inputs to give a meaningful summary and synthesis of what was in the study report in a way that it didn't when I asked it this sort of tangential question. But I think part of what I'd tell you is that in the same way that with any technology, you need some familiarity, that there is a real importance to playing around with this stuff in a context that's where you're not putting out private or confidential information, but that gives you a sense of what it is and what the outputs look like. In the same way that 20 years ago, we would have had a tough time recognizing a spam or phishing email, but now we kind of get a sense of what it looks like when we see it. I think there's value in getting a sense of, well, this is what an AI output looks like, and this is how it gets there generally, and this is, these are the things I should think about in using it. So let me pause there for a moment, and Christine, pass things back to you and Bryan.
Thank you. There's one area that is talked about quite frequently, besides the bias, is the confidentiality. And arbitrators are concerned about that, as are, anyone using AI. So Bryan, you want to start with concerns or challenges related to the confidentiality and the acceptance of the tools? Bryan?
Yes, and we've touched on this a little bit, but there are it's certainly a concern. There are compliance tools and encryption can mitigate some of these confidentiality risks. That's something that requires pretty robust IT processes or measures. So generally speaking, and I said earlier, like, if you're using a publicly available tool, you should, avoid putting any type of case information, anything confidential, anything potentially proprietary into one of these tools. That is what the model is training on. There are certain, even in a free account of ChatGPT, for example, I believe there is a button you can toggle to turn off training. And everyone, people have different opinions on how much trust they have in that. If the data is really being trained, any firms certainly that are using AI hopefully have enterprise level security around, which is a part of the contract an enterprise would have with OpenAI around the data that's entered. But also, this is why it's so important to maintain the human oversight of the output, and also, and I'm saying this as an AI enthusiast and optimist, not to over rely on AI. You can't use it too much. We've said it 100 times. We can say it again. It's a tool that's meant to augment, and it can certainly streamline workflows and make certain processes more efficient. But it's not something you should over rely on. And if there's ever question or concern about putting any kind of data into an AI tool, I would say don't do it. There are ways you can use some of these models and get equally good output without including personal information in the tools. So, and there are resources out there. I'm sure there are lots of education around how to do that. But if you don't have access to a platform that has enterprise level security, then you need to find the best ways to get that beneficial output without putting in names. And it could be as simple as redacting names, or constructing a prompt, so the way you communicate with the AI in a way that doesn't release that data. And I will say that while confidentiality is a major concern, I don't think it should stop people in their tracks with using the tools. I think that there's a balanced approach to it. I think you can still use the tools as long as you have the understanding that challenge, that risk does exist, and that there are ways to mitigate.
Thank you, Brian. Keith, do you want to add to the discussion on confidentiality?
I think, I mean, I echo everything that Brian said. And I think the other piece is to use some judgment when you use these tools. And some of that is when you select the tool itself. So there are, I think, different incentives in this market for different companies with different goals, right? If you're a tech company in AI or any field, and your goal is to raise capital and grow and turn a startup into a long-term success, there are incentives, right, to do things that look cool and wow investors and get press. And privacy and confidentiality are not always top of that list, because there's a notion of, move fast and break things. And that's not necessarily the tool I want to trust with confidential information from where I sit, right? That raises some questions there about whether that company is going to treat the data that's shared, even if it's fairly innocuous or bland or sanitized, in the way that I hope and expect, and as a matter of professional responsibility, would need to. There may be other companies that are more established where this is something that they are doing and pursuing, but it's not their whole business. And maybe I have a different comfort level there. Or maybe there are companies that are startups that are doing something new, but are very sensitive to what's going on in the field and sensitive to those privacy concerns, and understand that it's key that if folks in the particular field that they are looking to sell to and serve, they really care about confidentiality, care about privacy, care about those issues sort of as a baseline expectation for a product, that they're going to make sure that that's baked in. And I know from our discussions in preparation, it's something that's been important to the association too, and in looking at these different tools, and something I know you guys have had in mind as you parse and look and decide which ones are worth partnering with or exploring further. And so that it goes back to what we've been talking about. If you just grab an AI tool off the internet, or access a tool, or pick a platform that's free or that you haven't looked into a bit, I think the risks are higher than when you focus in on a tool that is designed and suited for the particular kind of work or task that you're looking to use it for.
Thank you, Keith, and thank you, Brian. Are there other trends or challenges or best practices that you'd like to share that we haven't covered today? I just want to make sure we get all our points out. Brian, was there anything else in terms of the trends, challenges that you'd like to share?
Well, I think that, the challenges, I think we've hit on, as far as trends, I expect that we're going to be seeing AI used more, especially in the workplace, as it relates to dispute resolution. It is on the rare side now, but there are many startups. There are a lot of startups out there right now that are beginning to offer these fully autonomous mediation platforms that are just run by AI, and maybe the parties will have an option to have a human mediator review the output. But we're going to continue to see more of these startups offering fully autonomous AI solutions for disputes. I'm seeing that more now for mediation than I am in arbitration. But it's certainly, that's going to continue to occur. And many companies internally are using AI for its analytical capabilities. They may be using AI to determine whether or not they should take a dispute to arbitration. An AI can look at past case outcomes and predict future cases. So I know that there are some major companies now in the US that are implementing practices similar to that.
And Keith, I'm going to put you on the spot. What do you think about autonomous decision-making or resolving, like Bryan just talked about the mediator maybe giving a mediation process, giving an outcome, but where's the human? Any views on that?
I mean, I think like it's always been, it's the party's choice. And if a set of parties think that that is the right tool for them, I'm not here to second guess that. I mean, like I said, parties could always say, you know what, we've got a dispute, we're going to flip a coin, and heads you win, tails I win, and that is a way to resolve a dispute. So if that works, and if that works maybe for whatever it may work for, I don't know that I have a problem with that. I like what I do, and I think that mediators bring value to resolving a dispute and to helping the parties resolve their disputes. And it really is, again, about that party control. But I'm not here to tell you that parties can't use an AI chatbot if it's just a matter of miscommunications, getting the right prompts or nudges might do the trick.
Could be efficient for those parties. Could
You
be.
Keith, you make a really good point when you said party choice, because human mediation is never going away. I don't think human arbitration, human court proceedings, China, there are other places that are experimenting with these AI courts where AI are making legal decisions. I don't think human mediation is going away. And I think that you making a great point about party choice, there are going to be certain disputes that make more sense to be determined by an AI, and that is up to the parties. At the AAA, we talk a lot about expanding access to justice. And if there are parties that want to use a more cost-effective AI-led approach to resolve a small dispute, then it's great that they have that option. Is AI going to be able to solely determine, a $150 million multi-party construction dispute? No, we're nowhere near that. But if you look at, companies like eBay and Amazon, these e-commerce companies, they've been using AI in their dispute resolution procedures for a long time. And so sometimes from on the consumer level, if there are parties that are in a dispute that maybe they cannot afford representation, maybe they can't afford to go through ADR or a court process, and they elect to use this, autonomous AI tool to help resolve their dispute. I think it's great that that option is becoming and will become available to people. So yeah, I just, with you saying party choice, I think that's a really important aspect of it.
Thank you, Bryan. In terms of how it should be used in dispute resolution, I think we've covered most of that, the summarization, the data extraction, timeline creation. Anything we missed there to give the audience kind of how and why it should be used in dispute resolution? Anything to add?
I will say that, and you said like generating timelines, which I think is a great use case for arbitrators. And parties will have different uses for it. But I will say, anytime I speak to practicing attorneys about their use of AI, if they are using AI tools to help draft briefs, or if parties going to mediation or are helping or using AI tools to help them draft mediation statements, I would just highlight there that it is rare, if ever, that you are going to take the initial output you get from an AI tool and consider your work done. Iteration is a very important part of working with any AI. And while it may save you time in the end, you are still spending time iterating and refining and reviewing and making sure it has your tone, which maybe I didn't do, Christine, with the agenda I sent you for this call today. But all of that's really important. So there's still a lot of work. People sometimes get the impression that it's the lazy way and AI is going to take over work, but there's still a lot of the human work involved in reviewing that output for accuracy and making it what you want. But, so yes, Christine said document summarization. There's also there's things that AI is better at than humans. So the being able to review tens of thousands of documents and extract information in seconds, that's just something that AI is always going to be able to do better than a human can. But then on the other hand, there are human qualities that AI cannot replicate. So when you're talking about mediation and you're talking about a mediator that has empathy and life experience, those are things that an AI cannot replace. So I think going back to what Keith and I were talking about earlier, there are certain cases that are a good fit for an AI decision making and certain cases that are not. Also, just another potential arbitrator use. If, with the consent of parties, if there's a transcript of a preliminary hearing, you can feed the transcript to an AI tool and have a draft scheduling order come out of it, as long as you have consent and the proper protocols in place for security. There are all kinds of ways that you can use it. It's just I'll reiterate, it goes back to understanding it's the good and the bad, its uses and its limitations.
Thank you, Bryan. Keith, do you want to add to that? Anything to add?
I think it depends so much on the tool. I could imagine with the right tool, with the right privacy and confidentiality protections, working through writer's block, right? This is what I'm trying to express in this paragraph. This is where I'm trying to get. What's another way to rework that, right? And might be good, might be bad, might be something I can iterate on, might make me say, gosh, my reasoning just isn't making sense. This isn't singing. I could see that as a sort of, like I said earlier, a second brain, right? To bounce some of these things off, not about the decision, not about the substance, but about the style or the precise words. Or, I think there is some potential, for that sort of use for the work that an assistant might do, where the arbitrator retains, all control over the decision, but maybe there's something there. It depends on the tool, depends on the trust, depends on the track record of the tool. So I haven't. Yeah, I think this is a field that is constantly changing and constantly iterating itself. And I think if we had the same conversation in a year, a lot of what we say might be the same, but it depends on what's out there and what it's able to do and what's acceptable and what's not, and how ethical guidelines change. And I think that's something that really came out of the survey results we talked about, that arbitrators, at least, and I suspect advocates, attorneys, and maybe even parties are looking for that guidance about, well, before we figure out what it's good at and what we could use it for, we need some guidance on what should we use it for? What's it okay to even try this on? And I think that, and having that and developing that, is going to be a boon to deepening the discussion and giving people the freedom and the comfort to try something out and say, all right, let me see if I can do this. I think this is within the ethical bounds. Oh, it did a terrible job. I'm not going to use it for that again. Let me try it for this other thing. That worked. That helped me. That saved me time. That made my work product better. That served the process better. Or it's almost there. Let me see if I try it a little bit differently. What if I improve the prompt? What if I do this? And so I think it is a process of iteration by by the companies that provide these tools. I think it's a process of iteration within the professions that use the tools. I think it's a process of iteration within the individual dispute and by the individual practitioners. And so it's a lot of fun that way. It's an area on the move.
Definitely on the move. You mentioned a year from now. I'm always finding a month from now, I learned something new. So I think some of the information you shared about keeping on top of it and knowing the tools that you're using, and it's a challenge. But I have heard some arbitrators that I've dealt with that it's complementing what they do versus changing necessarily. They still want those guardrails, want to make sure how they're using the tools complement what they're doing and potentially even making it a more efficient process. And isn't that what the parties want? But not replacing the arbitrator, nor the administrative agency. How to put that plug in there. So, in terms of, we've touched a little bit, and I do want to leave time for questions. Anything else you'd want to share about AI and mediation and arbitration? Thanks, Bryan, for sharing that story, and also Keith, you sharing. Anything else in that area, just its use that you've seen? And I think, Keith, I did have a question for you, whether you've seen any specific cases where AI has come up in terms of what the dispute is about, or potentially what a grievant has filed or has an issue. Have you seen any cases yet?
So I haven't had anywhere that I can think of where the dispute itself is focused on AI. That, for example, work has been lost, or something's been moved out of the bargaining unit, or that sort of a thing. We know it's coming. We know that in the most recent Writers Guild contract, for example, the parties negotiated really, well, they negotiated carefully on language that governs where and how AI can be used in the writing process, right, for screenwriters. So, that's a field where you can see it coming because the parties see it coming. What I have seen is where parties have presented AI-generated product as evidence. For example, taken an audio recording, run it through an app, and given it to me as a transcript. And one party did that, and I looked at it and I said, this looks like AI, but I bit my tongue. And then the other party did the same thing, and their transcript was different. They ran it through a different app and a different model. And then we had a little bit of a talk of, well, at that point, I wasn't keeping my mouth shut anymore. And I said, did you run that through an app? And they go, yeah. And then we edited it a little bit. Okay, did you run yours through an app? Yeah, we left the curse words in. I said, yeah, I noticed. And it was okay. It wasn't case dispositive. It wasn't anything like that. But they hadn't said it, and if I hadn't recognized it, and I had just gotten these two transcripts, it could have been a little bit of a mess figuring out why their transcripts of the same conversation were different. So that comes in there too. And I guess to bring it full circle, the more comfortable that as arbitrators, as advocates, as labor management or employment practitioners we are with this technology, the better equipped we're all going to be to deal with it when it comes in the cases as opposed to in the process, because you have a better sense of what it is. And when the parties say, well, this is a case about the use of generative AI to do ABC, you don't start from the point of, if you're the attorney getting this case in the door going, what is generative AI? Or if you're the arbitrator sitting at the hearing, you don't have to go, well, AI? What's that? And it gives you a better starting point, and I think it's beneficial to the process. So it all kind of has that virtuous cycle to it, that as you learn more about using it in your own practice, you get that familiarity for where you're going to see it in the cases and in the field.
Thank you, Keith. Bryan, anything to add there?
Well, I did want to, I know we're going to take questions if there are any, but I did want to share some additional resources that I think the attendees would be interested in. Just thinking about the future of AI. We know that how rapidly AI has advanced, really faster than any technology has. And one of the issues with AI is the lack of standards of use or regulations, laws. That's changing. It has been changing. I think the EU was the first to pass some pretty comprehensive laws around the use of AI. But in the US, there are states that have already passed AI laws. I believe it was Virginia recently, but Colorado has a recently passed law regarding the use of AI. And so I expect in the future for an increase in state laws passed, certainly, and other regulations and guidelines, local rules, things like that. So there are two really good resources for at least being able to track any orders that have been entered in court or rules around AI. So I'm going to put those in the chat. One of them is from Rails, which stands for Responsible AI in Legal Services, and they provide an AI use in courts tracker. It contains court orders, local rules, and guidelines from the US and other countries, so you can keep track of these developments. I'll put that in the chat. And then also the firm Ropes and Gray offers a similar AI court order tracker where they give you a nice map color-coded with the different types of orders that have been issued in courts in different states. So I'm going to put both of those, and they're stay very updated, which is great. There's other resources. These are linked through our Triple AI lab on our website, but I'm going to put the direct links to these tools in the chat.
Thank you, Bryan. Do you want to say right now anything about AI agents for the participants?
Well, I will say that, I mean, Keith earlier mentioned reasoning models, which are fantastic, much better than some of the earlier chat application conversational models that were out. And even a step further than the reasoning models is agentic AI, AI agents. Deep research is one that was recently released by OpenAI, and I think Google has their version of a deep research platform. But you can query it, you can prompt it, and it takes anywhere from 5 to 30 minutes to return its output because it's out there. An agent is an AI tool that goes out there and actually does all the work for you. And the great thing about some of these agents is that they provide the sources with the deep research, for example, in OpenAI, you can watch in real time exactly what the AI is doing. So it's looking at websites and articles and blogs and FAQs, and it's looking all over the World Wide Web, but it tells you what it's looking at, why it's looking at it, and what it's trying to glean from that information. It's really fascinating to watch. And even better, it provides you with a list of every single source that it researched. And that those are going to be linked either in the output or within the interface of ChatGPT. But that gives you, the user, the opportunity to actually check all of these sources and verify the accuracy of that output. So that is a good example of the human in the loop. But imagine, so agentic AI is really the next big wave. It's already beginning to happen, and it's happening. I think originally some of the experts, thought leaders in the field of AI, anticipated agentic AI coming around 2028 to 2030. You'd start seeing it. It's March of 2025. We've already been seeing it since the beginning of this year. So even the foremost experts in the field are not anticipating how quickly this technology is is moving. But just imagine if you take your dog for a walk and you come back and your AI agent has scheduled 3 meetings and answered 24 emails. It's a little scary to think about, but that is, it's in the near future. So definitely something to keep an eye out for and read up on it if you come across a resource.
Thank you, Bryan. Keith, any looking forward, future outlook? Want to provide our perspective?
Sure. Well, I mean, just to build off of that, something that AI could do that would save me time if an agentic AI can book my travel, right, and save me the time that I spend looking
Yes.
at flights or booking hotel rooms or booking a rental car. I'll have to get over trusting it with my credit card first, I guess. But that is something that does take up a lot of time, and it's non-billable time, and it's time that I could spend either working on other things or with my family or doing what I like. And so that actually is something that is important to my practice without affecting the cases themselves. So there are those real world, real life potential improvements that, even if I don't use it to draft my emails, because maybe, again, meticulous may be the nice word, but because I'm meticulous in what I send to the parties and what I, prepare, that may not be the right tool, the right use for me in the seat that I'm in the process, but there may be other things that really do make a difference that way. But I think it comes back to, you know, in my usage as an arbitrator, I think I'm always as exciting and as interesting as I think integrating technology into my practice is, and I really do. I have to be conservative in how I look at these tools and decide where to use them because, at least for me, it's not going to be a satisfactory answer to the parties in any particular case to say, oops, I went a little too soon, using that AI tool. And I think that's as it should be, but I think that staying on top of these developments is important for neutrals. It's certainly important for advocates. It's important for parties in these disputes. And just because I don't take to them quickly or arbitrators don't take to them quickly doesn't mean that that's the same for the other folks involved in the process. We each have different roles, we have different responsibilities, we have different concerns, uh, and that's okay. And I am an optimist about it, even if I'm cautious about where I see these tools being used in my practice.
Thank you, Keith. We never think we think we have too little for the presentation, but here we are almost at 1:25. I just want to, any parting comments, Bryan, for the group?
I will leave it with telling you that AI is here to stay. So if in the event you're not on board quite yet, I encourage you to get there because it's certainly a technology that I think will just continue to grow and change the workforce, change every industry. And I love it. I love it. Again, the enthusiast part of me, but it's certainly here to stay.
Thank you, Bryan. Keith, any summary, parting comments?
I think you got it all from me, especially given the time. But it is exciting. I am enthusiastic about what's, what we'll see next. And I think it's just, use with caution, use with care, and figure out the right tools and the right use cases individually. But I think there's a lot of potential.
Keith, I think it's okay to be a cautious optimist. I think that's okay today. Liam, did we have any questions that I didn't get to in the?
Not beyond that initial question, which the panel picked up. So I think with that, I would just like to thank you, Christine, for pulling this together, and Bryan and Keith for your time. Again, mark your calendars for May 12th. Any final words from you, Christine?
No, I'd just like to thank Bryan and Keith. They did the hard work here today, and I appreciate their viewpoints. So thank you. And Liam, thanks for hosting today.
Great. All right. Thank you. Take care, everyone. Thanks again.
Thank you.
Bye-bye.
Bye.
Thanks for having us.